This conference represents just one facet of the Bundeskartellamt's outstanding commitment to furthering a European and global dialogue and discourse on competition law and policy. This commitment is further strengthened on an institutional level through the European Competition Network and the International Competition Network, an institution in which you, President Mund, have not only been a significant participant in its founding, but have also served for over 12 years, ending just this past year, as its steering group chair. Secondly, my sincere thanks to the Bundeskartellamt and President Mund for the invitation here and the privilege for sharing some observations on the current challenges for the rule of law, particularly for the independence of the constitutional courts. Thank you very much for this invitation, and thank you so much for this warm welcome and without any major damages in the morning of Friday the 13th. The 23rd International Conference on Competition comes at a time in which the challenges for liberal democracies have converged to an unprecedented extent. Throughout the world, free and democratic constitutional states are under threat from wide-ranging authoritarian forces. Even within the European Union itself, we have witnessed authoritarian power grabs, which have been carried out through a weakening of the separation of powers and the dismantling of independent constitutional courts in particular, through means such as the restriction of competences, changes of procedural laws and court packing. Previous liberal states have seen a shift towards authoritarianism. In addition to populist challenges to constitutional jurisprudence and courts, critique as to fundamental nature of these institutions can also be found in scholarly literature. Specifically, in the United States of America, along with critique of case-by-case or method-oriented analysis, even the institution of judicial review has been called into question, and not just recently. The title of Mark Taschnet's book, published in 1999, Taking the Constitution Away from the Courts, speaks volumes. The ability of liberal democratic states to rapidly resolve problems of the state is not restricted to the executive or the legislature. It is also found in independent constitutional courts, which exist not just for the sake of freedom and constitutionalism as such, but also for the effectiveness and efficiency of this problem solving, which will be unable to come into fruition without the guarantee of a competition of ideas. There are various measures available to counter or even prevent authoritarian attacks on the independence of the judiciary and constitutional courts and Supreme Courts in particular. Today, I would like to briefly address two types of measures. First, external protective mechanisms, and second, the Constitutional Court's own ability to assert themselves, though due to time constraints in a greatly abbreviated format. External protection mechanisms are means by which states can adapt their legal order to better safeguard against authoritarian attacks. These mechanisms can, depending on the national context, be implemented in different ways. One example of this can be seen in the so-called Resiliency reforms to the Basic Law, the German Constitution, which were enacted in 2024. In order to protect the German federal constitutional courts from attempts to impair its functioning, a broad parliamentary majority enacted amendments that anchor certain vital conditions for the proper functioning of the court in the Basic Law. These provisions can now only be changed through a future amendment of the Basic Law, and are no longer subject to change by a mere federal law passed by simple majority, as was the case before the reforms. Rather, any future changes will require a two-thirds majority in both the Bundestag and the Bundesrat. Now codified in the basic law are, among other things, certain procedures for electing justices, the number of justices, as well as the 12-year term of office. This example shows that political actors may be well advised to take measures to strengthen resiliency, not just reactively, but also proactively, even when the democratic institutions of the country are not under any attack. Whilst the basic law, which has long contained provisions on other constitutional organs of Germany, now also contains extensive provisions on the Federal Constitutional Court, it remains important, especially with regard to safeguarding the conditions of the functioning of constitutional courts in general, to bear in mind the role of the constitutional courts in the debates regarding such reforms. Constitutional courts may have extensive powers, but it is primarily the task of the legislator to give specific shape to these powers, both in ordinary and in constitutional law. This distribution of competencies must be respected, even by constitutional courts, which would be well advised to refrain from trying to shape the discussion on these matters on its own initiative. Any attempts to do so would give rise to three risks in particular. First, doing so would disregard the constitutional distribution of competences. Second, due to the prognostic uncertainties inherent in many legislative instruments, such an approach would amount to the court too readily taking on a guarantee function and thus assuming institutional risks. And third, this would carry the risk of unjustifiably discrediting the legislator on points of the rule of law, although it may have a very good reason for taking a different position. Let me now shift from external protections of the constitutional courts to the court's own capacity to assert themselves. It is this capacity for self-defense that, as welcome as external protections may be, is at the very core of the discourse surrounding the preservation of independent constitutional courts. This is because the constitutional courts, whose role is precisely to bind and limit legislative and executive power, would be fundamentally called into question due to a structural conflict of interest if they were only able to assert themselves when the other branches of government which they serve to limit are prepared to protect them. In this regard, there are several possibilities available to the judiciary. These include, first, legal remedies that judges can make personal use of to protect their fundamental rights. Second, judges can, in both their official and private capacities, advocate for the importance of an independent judiciary, or in more general terms, for the importance of the rule of law and for the importance of democracy. This is essential because the ability of citizens to identify with the fundamental values of their constitution and the commitment to preserve such values are prerequisites for a functioning state. The third, and in this context perhaps most important possibility, is judicial review, particularly by constitutional and supreme courts, of measures that undermine democracy and the rule of law. My remarks today will be limited to this last aspect. If we consider not one specific court in particular, but instead the judiciary as a whole, particularly within the European Union, it seems only natural to begin by examining the lines of case law developed by the Court of Justice of the European Union. In addition, the case law of the European Court of Human Rights on the requirements of Article 6 of the European Convention on Human Rights which can also apply to proceedings before the constitutional courts, must also be considered. Within the EU concept of judicial independence, there are distinct guarantees of professional and personal independence. The guarantee of professional independence provides protection from orders and instructions, namely from attempts to assert influence over the actual process of judicial decision-making. The personal dimension is centered around the legal status of judges and, in particular, extends to the principle of irremovability. The professional and personal dimensions are not just intended as protection in individual cases, but must also be guaranteed as institutional safeguards through organizational measures and rules pertaining to the composition of panels, appointment, term of office, and the grounds for abstention, recusal, and removal of its members. The concept of judicial independence thus applies equally to the court as a whole and to each of its individual members. The various constitutional and rule of law traditions of the member states do not establish a variable standard for judicial independence under EU law among the individual member states. The national identities of the member states nevertheless require a standard that reflects restraint and thereby sets limits to the power of review of EU institutions. Legal mechanisms through which the European Union can review the independence of the judiciary of member states in its substantive and personal dimensions can be found both in primary and secondary EU law. However, the EU's review mechanisms are limited, including with regard to the standard of review, to the subject matter under review, by the intensity of the review, and the legal consequences of any violations for the member states. The example of the rule of law crisis in EU member states shows that efforts to combat it would hardly have been effective without the political decisions to impose financial sanctions. This reveals the limits of the protection that can be afforded by EU law. First, the need for financial sanctions ultimately requires that the EU has the ability to act on a political level. If the free and democratic state based on the rule of law were to be eroded, not only in individual member states, but in the EU as a whole, with authoritarian ideology also infiltrating EU institutions, this would dampen the hopes of political majorities for such indispensable financial sanctions to accompany EU law measures for the protection of judicial independence. Second, the protection that can be afforded by EU law would also reach its limits if the conditions required for the proper functioning of the Court of Justice of the European Union itself were affected. The effective functioning of the Court of Justice itself could also be the target of authoritarian efforts as for courts in the member states. And third, even if the EU and its institutions continue to function properly and in accordance with the rule of law, it has not yet been tested whether financial sanctions prove effective when targeted towards net contributors of EU funds or only when targeted towards net recipients of EU funds. It is important to note that even with the instruments available at EU level, the self-defense capacity of constitutional courts at the member state level is still indispensable. Domestic constitutional courts play the primary role in ensuring the rule of law within the individual member states. The same is also true for constitutional courts outside the European Union. A majority of member state constitutions in the European Union contain guarantees of judicial independence in the same vein as Article 92 and 97 of the German Basic Law. Under German constitutional law, the guarantee of judicial independence ensures that judges are free from outside instructions or other avoidable influences. It also provides protection against attacks on the legal status of judges who are appointed permanently to regularly established positions as their primary occupation. Thus, in the case of legislative disregard of judicial independence, constitutional courts will often be in a position to overturn such laws. In Germany, the Federal Constitutional Court can declare laws which violate the guarantees of judicial independence in Articles 92 and 97 of the Basic Law to be invalid. Even when a constitution does not contain an explicit guarantee of judicial independence, in many cases the same guarantees still apply. The constitutional enshrinement of the rule of law includes, at a minimum, the existence of independent courts. And the mere existence of constitutional rights often implies an associated legal protection through an independent judiciary. Without effective protection through independent courts, the freedoms enshrined in the Constitution would waste away. Without judicial protection of the freedom of expression, assembly, and the press, the principle of democracy itself would be largely undermined. The guarantee of legal protection through an independent judiciary is thus an essential characteristic of liberal democracies. The challenges to liberal democratic constitutional states of the Western model are considerable. A free democratic state under the rule of law is never guaranteed, and its foothold is always precarious. Nevertheless, confidence in the future is both permitted and justified. Crisis can also bring opportunity. It just needs to be discovered and acted upon. And forums such as the International Conference on Competition, which broaden the perspective beyond individual states and open up a European and international dialogue and discourse, and also on the question of resiliency of antitrust and competition authorities, provide a significant contribution to this process of discovery. It is in this spirit that I wish you all productive and enriching talks that are inspired by vision, confidence, and also joy. Thank you so much for the honor of the invitation.
So, President Harbarth, or I may say Stephan, as we know each other from times of university, thank you so much for your speech, for your inspiring words. The rule of law is particularly important as well for our community, for in the context of antitrust policy and antitrust practice. And you vividly illustrated the dangers for the rule of law. These dangers are maybe nowadays more frequent and more forceful than we were used to in Europe. In your opinion, what is the most immediate need for action in this context?
In terms of the rule of law, I have mentioned that I believe that it is important, of course, to analyze for the respective judicial systems whether there are sufficient safeguards. This is what we have done in 2024 in Germany, and which may also be very rewarding for other jurisdictions. What we need, of course, is a deep commitment to the rule of law. In societies, the rule of law cannot just survive on the basis of the wording of the constitution, but it requires a deep commitment of the people and also a deep understanding that without the rule of law, there is neither freedom nor democracy. So I think these are some aspects which are important with respect to the rule of law. But let me mention one aspect, I think, which is, in my perception, key to the success of the democratic liberal state. We are in a we are in a conflict between authoritarian systems and the system of the free democratic state. And I think there is some kind of longing of many persons for the speed of authoritarian decision making. Things are very complicated, and in a democracy they are always a little more complicated than in an authoritarian model, I think, and this is the basis for some kind of longing for authoritarian models. I personally do not share that confidence in authoritarian models at all. The failure of authoritarian models, not only in German history, has been unrivaled. But I do not share that. But nevertheless, we must make sure that the people feel that the democratic state is able to act in a very complex world. The ability to act is challenged more than ever. And we have to make sure that, of course, things last a little longer in democratic orders, but that they therefore produce the better results. And we must make sure that we refrain from any excessive normative constrictions, both for the state itself and also for the people, because I believe that this is one of the very key reasons why the concept of the democratic state loses a lot of support and a lot of confidence. So the ability of the state to act, of the free democratic state to act, to adjust our legal systems, to strengthen this ability to act is, in my opinion, key for the competition between the two models around the world.
Thank you. Thank you. Coming a little bit closer to our antitrust area, yes. The next panel this morning will discuss the role or the institutional design of antitrust authorities. So there are, of course, fundamental differences between the judiciary you refer to and the executive branch. And this is true for sure for the variety of challenges you have for the judiciary and the executive branch concerning the rule of law. However, do you think that there are difficulties which you mentioned which may arise as well in the context of the executive branch?
I think so. Of course, you have some very specific style of independence, which is of course different from the courts, but you have it. And independence is something that is not liked by authoritarian models and by authoritarian regimes, because their idea is, I do not need other independent bodies. The decisions can be made at the end of the day by one person. So of course, therefore, there is also a risk for the independence of any state body, including competition and antitrust authorities. But I think, to be honest, one must be aware that the constitutional protection is different. Of course, there is some constitutional protection, for example, in terms of the legal status of civil servants, etc., etc. But the constitutional safeguards are much lower than those of courts or even constitutional courts. I think that is very clear, and therefore it is a challenge for your community, because the ability to act of the state that I have mentioned before is something that is very closely linked exactly to your job. Of course, the ability of a state to act strongly depends on the economic power and on the economic potential of the respective state. We see that very clear these days. And in order to make sure we have a strong economy, we have economic potential, we need strong competition authorities in the world. That is very clear, and therefore the challenge is obvious. We need the independence of those authorities to make sure that competition works. We need competition to be economically strong, and we need this strength to make sure that the free democratic state can be resilient in the world we have today. And therefore, I think it is very important to discuss, as you will do, the issues of resiliency of antitrust authorities and the protection of their independence. Yeah, the success of a constitutional order is not only dependent on the wording. The success of this country, of course, depends also and maybe primarily on the wonderful constitution we have. But without the economic success in the 1950s or 1960s, we probably would have seen what the Weimar Republic had seen in the 1920s. So economic success is beyond the mere wording of a constitution key to the acceptance of the state by the people.
Thank you. Just coming back maybe a little bit to the aspect you mentioned before, if we consider the topic of the rule of law from a different angle, the implementation of the rule of law, the design of rights and remedies does not come without costs. Yes. It has a price tag in a way. Complex administrative proceedings and procedural rights, even judicial remedies may be regarded as overly bureaucratic and burdensome. How does the constitutional justice view this debate?
When we speak on the issue whether we need adaptations of our legal order in order to strengthen the ability to act, then it is very clear. We must be honest. We cannot then only say it is about blaming others. You cannot only speak about the executive branch. You cannot only speak about the legislator. Of course, you also must speak about the judiciary. And of course, we always have to analyze whether maybe some things in the judiciary are too complicated, whether something can be changed to come to results of the same quality without being too bureaucratic. This is not a discussion we only need for executive and legislator, but also for the judiciary. But I think what is more important these days is to make clear that we need a strong and independent judiciary. Why do we need it? The primary decision we have made is that we want to make sure that decisions in our systems are not only made by one man or one woman, but that they are the product of an intense discourse within society, because we are convinced that that produces the better results at the very end. And therefore we need a competition of thoughts, of ideas. This competition of thoughts and ideas can only work when we have an independent judiciary. If we do not have an independent judiciary, then the current minority cannot become the majority of the future. If we do not have the right of free speech, then democracy does not work. If we do not have all those rights, then freedom as such is gone. And therefore, yes, we have also to think whether the price tag could be lower, but we need a certain price tag in order to make sure that the basic idea, competition of ideas, are the better way to shape our future than the belief that there might be one person who is full of wisdom. This concept requires independence of judiciary, and therefore always some price tag, maybe it can be changed, but we need it. And this is something we must tell the people.
Thank you so much. So we are pleased to see such a diverse and international mix of representatives, of authorities, of the judiciary, of the legal profession, academia, and the business world. We are all here in the common interest of protecting competition and seeing competition enforcement. Is there any other message you would like to share with our competition community?
I think I would mention two messages. The first refers, of course, to your core activity. I have mentioned that the success and also the survival of our order is strongly dependent on the economic performance of our societies. It is about values, but it is not only about values. It is difficult to convince the people that an order is perfect that does not create wealth. That is very difficult. And therefore, my deep respect for all your contributions to strengthening our economy as one of the key fields of our society and as one of the key fundaments of the success of our society in a very competitive world. But in addition to that aspect that is related to your core competencies, I would like to mention something else. I believe that it is very important these days to demonstrate your commitment to democracy, to freedom, to the rule of law, wherever you can do it. It is not only about writing interesting articles on competition law. It is also about being active as a citizen. Whatever you can do, all of you can do, for example, a visit in the school. You can go to a school, maybe once a year. You can go to a class to explain them what is the rule of law. Why do we need law? Is law only complicated? Is it only a challenge? Is it only burdensome? Or is it maybe key to democracy? Is it key to freedom? Is it key to a happy future? Each of you can do that maybe once a year, maybe in schools, maybe somewhere else. And I just would like to give you the message, think about that. Is there maybe anything else also outside and beyond the very important world of competition law?
So,
yeah.
Dear President Harbarth, lieber Stephan, thank you for your thoughtful and inspiring address and your comments. Ladies and gentlemen, maybe again, please join me in thanking the President of the Federal Constitutional Court.
Yeah, thank you too. Vielen Dank.